I call the Honourable Member Andrew Little.
Thank you, Mr Chairman. I rise to make a further contribution on the Legal Assistance Amendment Bill in this very important committee stage. And Mr Chairman, I simply, and having listened to the Minister in his last contribution, reiterate the concern that the Labor Party has about the regime that is now to be set up for the recovery of a proportion of the costs associated with appointment of counsel for the child. And I am not reassured by the Minister's attempt at reassurance on just now. And I refer him specifically to Clause 27 of the bill, the new Section 131A of the Care of Children Act, and refer to the definition of serious hardship. Remembering that under the regime that the bill proposes, is that there is first of all a presumption that the costs or part of the costs of counsel for the child will be levied across the parties. There is scope to have the share between the parties different across each party. Understand that, but the basis on which a party or both might not be levied at all is on the grounds of serious hardship. And serious hardship is defined in subclause 6 of, subsection 6 of the new Section 131A in Clause 27, includes significant financial difficulties that arise because of the party's inability to meet, and this is the phrase I want to focus on, minimum living expenses according to normal community standards. Minimum living expenses according to normal community standards. And with all due respect to the Minister, Mr Chairman, that language is somewhat vague. What is a judge to make of minimum living expenses, and what is a judge to make of normal community standards? Understanding that that sort of language sounds like a very shifting sort of standard, the shifting sands of minimum living expenses and the shifting sands of normal community standards. And Mr Chairman, it looks to me like it is more likely that this provision in its current form is going to cause more confusion and anxiety than give any greater assurance. And perhaps the Minister could answer the question about what he understands or what a judge is to make of that sort of language when it comes to this sort of cost recovery. So this also cannot be separated from it. I know it appears in the previous part of the bill, but it relates also to the other powers of attachment that will now apply when it comes to cost recovery, including for cost recovery of counsel for the child. And it relates also to that part that allows not only attachment orders, but that attachment orders can be up to 40% of the net pay of a grantee of legal aid, or a grantee, or someone who has had the benefit of counsel for the child, or whose child has been represented by counsel for the child. So up to 40% of net pay can be the subject of an attachment order to meet these costs that can now be levied. And Mr Chairman, there is nothing in the bill, unless the Minister perhaps can point it out to us, nothing in this bill that suggests there is any potential for alleviation other than a general discretion for the court on this very vague serious hardship condition for a judge to avoid levying a party or both parties that have had the benefit of counsel for the child in their care of the children proceeding. So, sir, this still remains highly problematic for us. This does not give us any reassurance that this bill will not lead to some people facing considerable hardship and considerable debt. And once the amount is levied, it will be subject to interest, it will be subject to recovery action, not the least of which will be an attachment order that could see up to 40% of their net pay being extracted from them from a person before their pay lands in their bank account. That has the potential to cause significant problems for people, and to really create a great sense of fear to people who are reliant on, or who are in it, Mr. Chairman,
Andrew Little.
who are in the position, often not a position of choice, who are in the position where they are utilising, in this case, family proceedings, where they are subject to this type of levying. That makes the legal aid scheme a scheme not of fairness, not of ensuring access to justice, but a scheme that will become one of great, rather than fairness, one of great fear, that people will have, that they may be plunged into permanent or long-term hardship or poverty or destitution as a consequence. And that is not good. And as a matter of public confidence, what we need, Mr. Chairman, is a legal aid scheme that does what it intends to do: provide legal assistance for those who simply do not have the means to meet the cost, provides legal assistance to those who are often in a position where they must pay legal costs, must pay the cost of representation and advocacy, in a situation where they would prefer not to, in a situation where they have not necessarily chosen it. And these sorts of clauses, Mr. Chairman, are enough to suggest that a legal aid scheme that is built on these sorts of provisions will not be a legal aid scheme worthy of the name. And Mr. Chairman, I call on the Minister and the Chair to give some clarity about just exactly what the government has in mind when it comes to recovery of costs for these matters, for lawyer for the child, under this part, and what it means in terms of the test for serious hardship for a party to have or to be afforded their minimum living expenses according to normal community standards. Because that is not meaningful to me, and any black-letter lawyer looking at that is not going to be reassured that this is going to provide any assurance at all. So, sir, that remains a very important and a very serious question in terms of this very important piece of legislation. Given the changes that have already happened now too, that there are going to be costs and expenses that lawyers are no longer going to be willing to pick up, whether it's the $50 user charge or other charges that may be imposed. Lawyers providing this sort of work under legal aid are simply not going to be able to, under the current regime, to be able to pick up those costs, and they will fall on the parties. These are already impecunious parties. That's why they are seeking legal aid and apply for legal aid, and to then be subject to a further test of serious hardship does not look like good justice to me. So, Mr. Chairman, let us hear from the Minister on those points.
Mr. Chair. I call the Honourable Member Chris Whawhoi. Taloha ni.
Taloha ni and tēnā koe, Mr.